So Parliament returned today, and let's dig into it a bit. It's setting up to be one of the very interesting sessions of Parliament, and already we're getting a fair bit of controversy in the House, but also looking forward to some of the big ticket items as far as bills are concerned that should come before this particular Parliament now that they've resumed. And we're going to be looking at some of the key things, but I'm interested to also speak to him about a whole host of other very important matters that he has been involved in. I'm pretty sure you know that he was one of the few MPs who were suspended in the wake of the controversies last year having to do with the vetting issues. Well, that particular report that was investigated and put out, nothing has happened to it. And so Rockson-Nelson Dafeamekpor is my guest, who will tell me in essence what really has happened on the back of he and others being suspended. That suspension was lifted. A committee was set up to look into the matter. We've not heard much from there. And then I'm pretty sure you know the OSP bill itself that was laid. We'll talk about that. And then there's a whole raft of other bills that this particular Parliament will be dealing with. Now that Parliament is back, you want to stay with me. There are a few of them that we are interested in. The legal education bill, for example. What about the Anti-LGBTQ Bill, which of course he is a key person on that as well. You want to stay with us because there are so many other key parliamentary matters that I would seek his views on. And today we have the story of how the government is planning to change the name of the Kotoka International Airport to the Accra International Airport. There's a bill coming to the floor, but what really is the rationale? He may shed some light on that too. Stay with me here on PM Express. And thanks for staying with us here on PM Express. This is always brought to you by Syntex Tanks, also brought to you by Pepsodent Cavity Fighter. My guest in the studio with me is Rockson-Nelson Dafeamekpor. He is the Majority Chief Whip, and I'm delighted to have him. Parliament is back after a long Christmas. Exactly. It's back with a bang indeed. A lot has happened since you went away. And today when it started, both sides, the leaders addressed the House. And you could already see this, is it meeting or session?
It's the beginning of the session, that's for the year.
Okay.
But the sessions are broken down into meetings in the public service balance. We call it the quarters.
Okay.
So the first quarter will be the first meeting, which will come to an end sometime 31st on or before 31st of March,
okay,
2026, so that we can go for the Easter break, come back, do the second meeting. That normally will take us, is usually the longest. We do like 3.5 months. So that will take us all the way to 31st of July, or sometime early August. Then we break for the summer holiday, the long vacation, and return sometime late September or early October, and do the budget, and then end the year. So it's cyclical.
So this is a meeting that just resumes. Yes. It's setting up to be a very interesting packed one as far as bills and legislation is concerned. What are some of the key ones that you're looking forward to that should be on your table?
The keenest of all should be the one that will be of some interest to you.
Yes, of course.
The legal education reform bill. As you know, the history, we've been fighting for some reforms within our legal education. And I pride myself as being the champion of this, because at the time I believe in this, a lot of people thought that I was waging I was engaged in a quixotic fight. Don Quixote, if you know. How do you fight the treadmills? But we are here because the injustice, the sheer injustice that the current system has wrought on a lot of people, families, we had to do something. Even sometime in 2018-19, Oh, you have been here for, you know, the first time I encountered you when I was Oyome's lawyer,
yes,
like 15 years ago.
Yes. Long time ago.
Long time ago. Yes. So, sometime 2018-19, reports emerged that those who had passed or who were passing the entrance exams to enter the professional school of Mokola, they were being dogged at the interview level, and they were asking a lot of very interesting questions. For instance, do you have a lawyer in your family? Once you couldn't point to a lawyer in your family, you were damned. So the matter got to a head to the extent that my committee in Parliament, the Constitutional Legal, the matter, we had to be engaged with the matter. And then when the General Legal Council came, we saw the enormity of the problem. And the year later, so we fought for the interview to be dropped. So eventually they brought a regulation that catered for the elimination of the interview. But the exam stayed because of the arguments regarding lack of space and all. So Parliament had to accede to that request. But it was again abused. Because you could write an exam, you will pass. Or if you fail and you exercise your right of a remarking, it may never happen. Even if it happened, it was shrouded in secrecy, all sorts of things. But what really brought the cameras back for me was the fact that initially it was 22, but some 11 students were established, candidates, were established to have gained admission to the law school without first writing any exams at all.
I see.
So the report itself used the term backdoor approach. So what happened? The General Legal Council itself set up an ad hoc committee to look into this matter, this allegation. And when they brought their report, it was so damning. They didn't want to reveal it, disclose it to anybody. But I got a copy. In that report, some 11 students or more had been determined that they entered the law school without writing exams. So what they did was to quietly ask them to go away. But we can't do things like that. So I decided to then introduce a private members bill with my brother Susu. Senior Samoku Jeto won't have it. He went to town practically, and I'm saying this publicly because that argument, we had it on your channel, on Joy. And threatening us, we small boys, you recall those comments. We're not perturbed. So our senior Dominic Ayini then joined us to do the private members bill, but eventually we couldn't succeed. So as key NDC frontliners, we made it a point that we need to do this. So as part of the campaign, we pushed it through the manifesto committee, and it received some good recognition and
Indeed,
acceptance.
it was in your manifesto. Yes.
So once we got in, we said, no, once we have our foot in the door, this is one of the first things we should push. Even then, we took our time to engage. So we spent the whole of last year engaging, and here we are. This is the final product, I should tell you. Because this evening, just before we adjourned today, we took the committee's report for the second reading.
Second reading already?
Second reading. Because it's been laid and referred to the committee. The committee had done extensive consultations.
Okay.
And brought a report today. So this evening we took it. So that's the final product that is ready for consideration by plenary, I'm sure from tomorrow or within the week. Now, Evans, this is going to going to remedy the situation where we have only Makola and some other allied campuses running the professional law program. You see, what we are doing is in consonance with Article 25(1), I believe, Clause E or so of the Constitution. Look, there must be equal right to education. Embedded in the right to equal access to education. No, right to education is also equal access.
Yeah.
And equitable access. For instance, I should be able to live in Ho and get trained and become a lawyer without even stepping a foot in Accra. I should be able to stay in Kumasi and get trained and become a lawyer without stepping foot in. So it should be possible for me in Takoradi, Sekendi, Takwa, Tamale, Boku. But for somebody in Avrongo to travel all the way to Accra to receive legal education, we've long gone past those days. So we are opening access, but quality, the issue has been quality.
Yeah, that has been the main argument.
We are not compromising on quality at all.
How are you going to ensure that in this bill?
Now, so there are a lot of strictures provisions that deal with strictly, or the strictures have been canvassed in such a way that accreditation, the checklist for our accreditation is still strict. For a faculty to meet accreditation so they can run, they can train first in the LLBs and train in the professionals before you prepare your candidates for the national bar exams strictly. You go through a very rigorous accreditation regime. Even lecturers, for you to be able to lecture in the law, in a faculty or in a school, we are going to set standards.
Okay.
You know, so we are not backing down on standards and quality. So everybody should be assured. But we want to open the system. People should. And it's also a revenue generator. Anybody who sees this as it's retrogressive in nature, I'll be surprised. Because there are people who want to train and they are ready to pay. Do you know how much Ghanaians go to Gambia to pay?
Yeah.
A lot of money. And when you go to, look, they'll reject you in Ghana. People have first class in LLB. They are told that they can't pass the entrance exams, or they wrote the entrance exam and they are told that under some strange circumstances they failed. They can't even ask for a remarking. They find some funds. They travel to the Gambia. They go and top the class in Gambia. Yeah. Sweep all the walls. Same is happening in Sierra Leone. Same is happening in Malawi, in Botswana, in Zambia, yes, Lusaka, in Tanzania, in Kenya. And above all, Rwanda is the most favorite destination because we share the same common law jurisdiction with them. And those who can afford, they go to the King's Land in England and get trained. Even when they do all that, that's not the end. Some are even going to Nigeria here now.
I see.
Meanwhile, when we were here, Nigerians were coming here. So I was in class with some Nigerians. When you come down, there's something called post-call. Mm-hmm. You are a trained lawyer, but in this jurisdiction, you must also be called to the Ghanaian bar. That process that will make you be eligible to be entered onto the roll of lawyers is called post-call. The cost of that post-call has perpetually been pegged at the Ghanaian cedi equivalent of £6,000.
Wow.
That's how much it costs for a foreign trained lawyer to be taken through the basic requirements of some courses here so that the person will be eligible to be called to the bar. £6,000 equivalent. So again, money and economic factors become a bar. So there are a couple of lawyers, they are around, but they can't practice in Ghana because they've not been entered onto the role of lawyers in this country. Because of the £6,000 bar, that will go.
Okay.
Then initially the idea was to take out Mokola at all, but we think that Mokola is still very critical in the scheme of things. So we'll maintain Mokola for some training, professional training programs. But essentially the faculties, they don't like to be called faculties, they want to be called schools. So like Jimpa, like Legon, my own school, they'll be accredited.
Okay.
So when you enter, you are trained for the LLB. After the LLB,
the 2 years.
Yes, whatever training or the sieving process they will introduce will also follow some requirements of law. And so when you qualify, they train you in the professionals. Then you graduate. They award you all your certificates.
Then you have to now sit for the bar.
Now you have to prepare and sit for the national bar exams. I'm of the idea that we should have it twice in a year, maybe one in January, one in, say, July. Every year, twice, you know. And so, but that will be left with the Bar Council, the National Bar Council.
So that's where you sift. Those who pass, you're called to the bar.
You're called to the bar. When you sit for the National Bar exams, you sit for it, you pass, you get called. If you don't pass, you prepare, you try again.
And I read in this draft bill, a person who successfully completes a law practice training is to be awarded a law practice training certificate by the university.
Yes.
And it's important that the word is university. Yeah. So there's several universities, both private and public.
Yes.
That will be
because they'll be doing this under accreditation.
Okay.
So you see, under Article 25.
GTEC?
No. GTEC has a role in terms of the curriculum development. But there will be a body set up for, but they will be working in consonance with GTEC, because GTEC is also set up.
Is it GLC? Or you're scrapping GLC?
We are scrapping GLC and setting up a Legal Education Commission.
Okay.
You know.
It's a commission?
It's a commission, yeah.
That sounds like it has a lot of teeth.
Yeah. I'm even arguing that it should be an authority. So when we get to the floor, we'll look at it.
But as it stands now in this draft, it's a commission.
It's a commission, yeah.
And I also see here, a provision is made for the National Bar Examination Committee. What's that? Yeah,
there will be a body that will administer the National Bar exams.
Separate from the commission?
It will operate under the aegis of the commission.
Okay.
You know, but they will be in charge of the National Bar exams. You know.
Okay, so but what then happens to the GLC? It will exist as a supervisory...
It's a reform. It's a reform. Because a lot of lawyers are not happy, for instance, that lawyers get disciplined by judges. But we lawyers, we don't ever get to discipline judges who err. So why should a judge discipline me? Judges discipline themselves under the Judicial Council, which is a creature of the Constitution. There are subcommittees there are disciplinary committees as a subcommittee of the Judicial Council. They discipline erring judges. Petitions go there all the time. And so if there is a body that is supposed to discipline erring professional lawyers, why should judges dominate it? You know?
But this doesn't reform that, right? There's a separate conversation. Or it's in this one?
We'll deal with it when we get
But what is certain from what you're saying is that you are stripping the GLC of its education responsibility.
Yes.
That it currently still has. Okay.
Yes.
Okay. So that is very interesting indeed. What are the timelines, knowing what you know of every parliament operates? You are you wield a very powerful position on this matter.
Actually.
Before March, before you rise for this in this...
I think by next week we should pass this.
By next week?
Yeah.
It becomes law?
Yes.
Okay, if it becomes law next week, when does it take effect? You have a moratorium?
If we pass it by next week, then I believe that by the time our president returns to the House for the SONA, where we normally, the State of the Nation's address, which is likely to be getting to the tail end of this month, he would have signed it before, because I want it to feature in the SONA as part of the State of the Nation. So he would have assented to it. And once he assents to it, we will give some transitional period for its implementation. And that's it.
Central question, for those who will have done LLB this year, they are not sure whether they should go and stress themselves with it. Should they wait?
About 2 hours ago, when we were in the throes of debating the principles of the bill, you have to see how agog social media, where the law students dominate. It was agog. And so the questions kept filtering through, somewhere sending them to me. So all of us, if you look at that Venn diagram, the number of LLB holders who fall into that subsect must have received their training or their LLBs from, say, Legon, from, I still call it IPS, UPSA, from JIMPA, from UCC, my school, from Tech, from UDS.
Mount Crest, all the private.
Great. Yeah. So you pray that your mother faculty will meet the accreditation checklist and get accredited. So in that case, it's easy. So for instance, Senior Ansasari should be able to take me back if I had obtained my LLB from his school and I'd been, for some reason, I couldn't proceed to Mokola. He should be willing to take me back to do the professional. You understand? It should be easy. So the faculties, it's easier for the faculties to readmit their own products.
The only bar is accreditation.
Yes. So now so what's interesting is that in doing the stakeholder consultations, we engage nearly all the faculties that matter. Their deans also participated. So all the faculties have been put on notice that for purposes of accreditation, these are the checklists these are the boxes on the checklist you must tick. So for instance, enhancing your library. So we have indices for a library to be qualified as requisite for a law faculty, some volume of books, articles, all those things, online and in hard copies. Faculty members, they are, in terms of academic qualifications, minimum PhD. That's what we are looking for.
Okay.
So those faculty members whose highest qualifications are like LLM, research-based LLMs, are being put on notice to proceed to quickly do the PhD, so you can continue to be relevant to your faculty. Otherwise, these days, the young guys, they are clocking the PhDs in law, and so they will come and dethrone you. Because of the frustration in entering law school, somebody has a first class, LLB first class, which is, until recently, some of the rarest of qualifications to obtain in academia. But the young guys are clocking it now. So once he's frustrated in entering law school, they quickly do the LLM, either coursework-based or thesis. Thesis normally 2 years. They do well again. The faculties take them on fellowship and studentship. They do the PhD in 3 years. He has a PhD in law, some refined area, maybe international trade law, intellectual property rights, land law, company law, all those things, you know. So they are ready, and they can lecture. So
but you also have a place for experienced hands who are
great. That is why we are putting the faculties on notice. For instance, Professor Kumado, who taught me arguably some of the best things in constitutional law, never got a PhD. But he rather supervises people with PhD because of the depth of experience he garnered. So if we introduce this law, anyway, he's on retirement now. He's old, he's tired, unfortunately. So if we introduce, then people like that cannot, unless they go and take a PhD. So it's a way of... Yes.
I mean, you're qualified to teach.
Yes. In fact, I have done some teaching.
Exactly. So what do you mean? Once you pass this, you can't do that anymore?
Yes.
Regardless of...
So I've actually started my PhD.
That's interesting.
Yes.
Even judges. I know some judges teach.
Yeah.
So judges can teach.
A lot of judges have their LLMs. And because of their experience on the bench, they teach the professional courses. I think it's only in a few faculties that the judges come down to teach the academic program. But the judges normally will teach professional courses like...
But they can't go in the faculty and teach.
Yes, in this one.
Because the law says you must have a...
Yes, so this one... But I think you are raising a very good point. So we may have to create some exemptions that when the person is like a Supreme Court judge or judges of the Superior Court, we may have to create that small exemption for them because they will teach the professional courses like evidence, criminal procedure, civil procedure, advocacy, legal accountancy is also assuming some professional interest there. Which other? That's conveyancing, drafting. How to draft the legal document. It's also really a very serious area in practice. You know, how to plead. You know, pleading. It's taught in civil procedure, but mastering, if they say draft a deed of conveyance or a deed of leasehold, is different from a tenancy agreement. And it's conveyancing that will teach you that. It's conveyancing that will teach you how to draft, let's say, a grant, a deed of gift, you know. So the legal term tells you what language to deploy, you know. So it's very important that, for instance, a resolution, a company resolution, you need to know how to draft it because it has a peculiar language you deploy, you know.
So that is the legal education bill, and he said it that you can take it to the bank. It's going to be passed. He's very confident.
It's done deal. They should consider it as passed
next week. So that's the good news. Let's talk about, so which other bills do you consider to be big ones for this meeting?
Yes, the Security and Intelligence Bill.
Okay.
It's also before the committee. Committee should be ready with the report, if not this week, next week. Then we have the Spousal Property Rights Bill, which is interesting, a private members bill from some of our ladies.
Okay.
Will also feature. Then the LGBT, the Ghanaian Family Values Bill.
Is on the list?
Yes, yes.
For this meeting?
Yes. Okay. It's one of
because you know the minority had accused you, I mean the NDC side, of playing politics with it and sitting on your hands.
They are playing
and pretending that you want it when you really don't want it.
They are playing hypocritical politics. Because if as we were here, when it took us like 3 years, with all the frustrations we went through to pass the original one, we got it passed under a lot of issues, but it was passed. The president then decided that he won't sign it. It became a national issue, topical matter. I went to court to actually compel him, that the court should compel. So I brought an application, mandamus, to practically compel the president to receive the bill as passed from Parliament and sign it.
Or reject it.
Yes.
And then in which case the constitutional process would have triggered.
Yeah. They avoided all that. You know, this famous letter from Bedi who became also a topical matter and eventually left office. But you see, what hurt the system, what hurt a lot of people is that the president is a very experienced lawyer. And he knows the Constitution better than me. And he knows that under the provisions in 106, 107, 108, thereabout, he knows what to do. That if they bring a bill to you and you no assent to it, there are procedures provided under law for you to trigger. You refer it to the Council of State for a number of days for them to advise you if they advise. Then you attach that advice and refer it back to Speaker with your memorandum detailing the reasons why you assent to it. And when that comes, Parliament will have no option than to consider those grounds as a result of which you are refused to assent, and Parliament will include it and have it passed. But he didn't trigger. He knows that if he had triggered that, Parliament could actually proceed to pass it and will attain the force of law. Yeah. So because he knows the provisions and understands the legal implications, he danced in between and left the bill in abeyance. And we went to court. Richard Sky went to court. I also went to court. And they told me that because I didn't go to court with the mandate to the Supreme Court, of course, you couldn't have gone to Supreme Court with the mandate. It's a high court matter. So the judge said, well, his decision will abide the outcome of the Supreme Court decision, which got delivered on the 18th of December, 2024. Up to now, he's not delivering my ruling. So my case, my application is also in abeyance. Yes, it's really moot. Yeah. So when we won and returned to power and they began playing politics, I said, oh, we have done the hard work. All the hard work, we have done it. But the president, what is refreshing is that His Excellency John Dramani Mahama is ready to assent to it. He's giving his indication. Say if you pass it today, I'll sign it the next minute. So the bill came. Speaker referred it to the committee. They are supposed to do some consultations, but it got the euphoria got swallowed by the coming of the budget. Now that era is gone. once we are back after the Christmas and New Year's break, it's one of the bills that will be brought back to the front burner for us to deal with quickly and have it.
Your good friend, Dafeamekpor recently said on January 26th, quote, "We hold the view that NDC use the anti-LGBTQ law only for power, and now that they are facing the reality, they want to find a way of running away from it."
So you should ask Dafeamekpor what happened to the Ghanaian Family Values Bill that was originally passed. He will struggle to give you a response. So as a leader, you should stop playing politics. You should be interested in building consensus on the matter. When we sponsored that bill, we were 8. We had a lot of MPP people, but eventually they chickened out. It was only in Team Fojo who stayed. Even then, I'm saying it on authority that we never saw him participating actively. So it was me, Sam George, and occasionally Bejra, and then rarely Adjoan Tosso. We led that bill with the support of Speaker and some others. And the faith, Moses Fuamweni was doing the orchestra from outside Parliament. And we got it through. So it is that kind of system they must build.
So how do you explain why he has now become more vocal than the...
It's the politics. Now he thinks that he now thinks that he can play politics with it. But that's not how you do these things.
Can you say with certainty that you will pass this bill?
I am saying, I am not the one who will sign. So,
I mean, Parliament must sign.
So let me explain. Hitherto, I drove the bill with passion. Sam George and I, we got it passed. The president refused to assent to it. That was what killed that bill. So my boss, Sinayariga, said, the bill should be considered passed because it had been passed. So constitutionally speaking, what is the fate of a bill that was no longer a bill, that had become an act of parliament, but pending assent? It was something which we ought to have tested in the Supreme Court. Because a bill only dies with Parliament. But this one, it wasn't a bill. It was an act of Parliament.
And I guess that's what Mahama Yaraga's point when he...
No, it was something we discussed and he ventilated.
That he had left the domain of Parliament.
Good.
And so
we had ventilated it. Because you see, in doing these things, it costs money and resources and time and everything. So technically speaking, we are going to go back to spend money, time, resources, parliamentary hours to go through what we have already gone through.
But you can assure that you will pass it.
I am saying the person who signs says my pen is ready, the ink is dripping. If you bring it today, I'll sign it the next minute.
Will you bring it?
We will bring it.
Okay.
So we want to assure the nation and all the faith-based institutions and religious bodies who are interested, both sides of the major religious organizations, both Christians and Muslims, that this bill will pass it just like we did a year or two ago. But the difference is that the president, before even we kickstart that process, he's ready, he's in readiness to sign.
There's another bill that you championed that was aborted, the OSP repeal bill.
Yes.
Why did you withdraw it?
We were engaged by His Excellency the President, and he said, I share in your passion, but let's give them opportunity to... your concern is that they are not delivering as much as, if you compare the resources we are pumping into that office, we are not having like value for money. So he says, let's re-engage them. Let's let them understand the expectations of the people, including you leaders in Parliament. And so they must up their game, they must do more than they do now to warrant or to deserve the amount of resources we give them. Because my argument and that of my boss is that we give them an equivalent of what we give the Attorney General. The Attorney General has regional offices in all the 16 regions and attends court in all the districts, the circuit courts, and all the high courts dotted around this country. Sometimes even with private vehicles. There you see the principal state attorneys, senior state attorneys, assistant state attorneys, chief state attorneys attending court in their private cars. In the other regions, not in the capital. Even in the capital in Tema, when they do private car, because they don't have official cars. So if we double that resource, the Attorney General can then do more. Because if you see the volume of cases they dispose of or handle in a year, criminal, civil, and other legal work, even bills, nearly every bill that you see, it goes through the Attorney General, the drafting division for them to do this. And they get 250 million Ghana cedis on the average every year. We give 250 million to Kisi and his handful of staffers. And every day he will report that I'm investigating 15 cases, I'm looking at 20 other cases, I'm prosecuting about 7. You know, and I think that we are not having value for money. So these were the perspectives from which we're operating. It's not as if we don't value the essence of fighting corruption and corruption-related matters. I was very central and instrumental to passing that legislation. So it's about the office holder. If the office holder can do more, I have been he brought a report and said he wants to open regional offices. We supported him. He wanted to recruit about 250 or more special staffers so that he can operate in the regions. We supported him. But all those things haven't happened. You asked for bulletproof vehicles. We agreed that because of the nature and character of the work, specialized nature of your work, we approved that you can use bulletproof cars for your operations. So a lot of your senior staffers, including you yourself, you drive around in bulletproof cars. We didn't give you bulletproof cars not to deliver. We expect that you will deliver. But to sit in a bulletproof car and be prosecuting 7, 8 cases, no.
So you still hold the view that you're not getting value for money from?
Yes, but because the old man, we believe in the wisdom of the old man says, let's give them a bit of time and see if they can improve. And they released their mid-year report, I think a couple of days ago. I've seen some improvement. This time they are able to indicate the actual things. So when they tell you that we are saving money, I ask you, what's the meaning of savings? So this time they've changed their narrative. They're able to point out properties and those that have been seized and their value. So it's I believe they will do more. You know. So for now, we are staying in our hands.
I happened to interview the General Secretary of your party. He sat in the same chair. And he said this, quote, in reference to you and the majority leader, that he appreciate the work you're doing, but he says, quote, they are not an island. They are operating as part of the party. So major decisions have to be done in consultation with the party. We don't need to go through that into the future. And that goes especially to the chief whip yourself. Quote, he sometimes has a tendency to want to hasten without proper consultation. And that I can leave it at that. And then he didn't want to. As you can imagine, I pushed him.
Yes.
I'm sure you saw that.
Yes, and he's my mentor, actually. He's one of the people who I lean on, I go to for advice on a lot of political issues. I won't fault him. It's his assessment. So this matter has come to me. And you see, let me say this. See, the work that we do, especially as chief whip, if you understand my role, it's fluid. Things happen with some fluidity. And sometimes if you don't act, by the time you place calls, the damage would have been done. Look, this Kpandai matter, for instance, a lot of people don't appreciate why I have this passion. See, we had the seat. And the gentleman, Wakpal was such a formidable MP when we were in the 8th Parliament. He was part of the team that we used to resist a lot of things on the floor. So when he got into trouble, you expect that his bosses in Parliament will have his back. And I just didn't have it, but I understood the problem that he brought to me. What was the problem? They used violence to take his seat from him. And if you interrogate the violence, it led us to a lot of conspiracy theories. Look, I have here the Hansard of Parliament on the 7th of January. In this 7th of January Hansard, apparently the Electoral Commissioner, Jane Mensah, on the 23rd of December, listen to me carefully, Evans, she wrote this letter to the Clerk of Parliament, 23rd.
23rd.
23rd. What date is this?
Okay.
23rd December. She said, in response to a letter from the Clerk of Parliament, she said, I bring you greetings from the Electoral Commission and trust that this letter finds you well. I write to acknowledge receipt of your letter dated 17th of December 2024 with reference number that. Kindly find attached the writ of election for parliamentary elections held on Saturday, 7th December 2024 for 274 candidates elected pursuant to Regulation 43 2B of CI 127. Please note that there are 2 constituencies which have issues with their collations. The Commission will notify you when the issues regarding the 2 constituencies have been resolved.
And this included Kpandai?
Yes, and NDC. So here's Kpandai. In the writ of elections that she sent to Parliament on that 23rd December, it was this date that we used to file the Kpandai election. See, that's Kpandai. Kpandai is the 218th constituency out of the 274. Now, you have his director of elections appear in court to say that the results were gazetted on 24th. Do you appreciate what I'm saying?
Yeah.
On 24th December, when the commissioner herself has written in compliance with law that she had gazetted the results on or before 23rd December, as a result of which we went to Kpandai. Now, something very interesting happened. Subsequently, she indicated that there were only 2 seats that were outstanding. That also turned out to be false because on the 2nd of January, Samuel Tete, who went to court to say that the results were gazetted on 24th December and not her boss date of 23rd December 2024, now sent another notice for gazette notification for Domiko Abenya. You remember Domiko Abenya was in abeyance. Yes. That was 2nd January 2025. Then on 5th January 2025, the same Samuel Tete wrote again to the Clerk of Parliament. This time it wasn't the commissioner who was writing. It wasn't the chairperson. It was Samuel Tete. Now, he writes to Parliament again and says that, I bring you greetings. That's for that one. That's their cliche. Following the completion of the collation of polling station results for Okankwe Central, Tema Central, and Techiman South constituencies, kindly find attached writs of election for the parliamentary election held on 7th December 2024 for the above mentioned. Even 2024, he got it wrong. He wrote 2004. So if his boss had already indicated that there were only 2 seats outstanding, how come Samuel Tete was now sending gazette notification for 4 seats when the boss had already indicated only 2 outstanding? And that was not all. This is where the problem, this is where the EC must be investigated. So with this letter, because they've created a problem, now you can't add 4 to 274 and get 276. So they had to clean it up. So they now directed the MD of Assembly Press to now print the 6th January Gazette notification.
Which are that many constituencies? Which
contain the 275 constituencies except Ablekuma North, which we rely on the morning of 7th of January 2025 for our swearing in. So you actually will see that this letter actually ended in Parliament on the morning of the 6th of January, plus the overhauled Gazette notifications. And these are things we have discovered.
Because the date of Gazette is everything.
Date of Gazette is everything.
Because if you go to court and you're not within, that's why you lost the Kpandai case primarily.
In fact, we haven't lost.
Well, in the Supreme Court.
No, Supreme Court has been misled. Because these material facts were all hidden from the Supreme Court. Look, their lawyers stood in court and said that when Justice Puaman queried about the date inconsistency, they said it was a genuine mistake. But I have established over the time that there was nothing genuine about this. It was deliberate.
To what end?
They had to do it to align with the NPP case that the Gazette notification was 24th, and therefore we went to court prematurely. Meanwhile, we went to court on the day Jean Mensa wrote to Parliament, 23rd. Then we said, okay, if you had cleaned up the entire, because the Gazette notifications were in a confused state, because the seat numbers had exceeded those constitutionally mandated. If you had gazetted 274 and you had gazetted another additional 4, you have 278 seats. Where is the overlapping 2 coming from? So they took steps to clean it up on the 6th of January. Now he comes to court and denies the 6th of January Gazette publication.
As an error.
As an error, and calls it a genuine mistake. This is the case that a lot of people are not appreciating. I'm not passionate, but it is the...
But what if indeed it's a genuine error?
Hold on. It is the injustice done to Wakpa.
But what if indeed it's a genuine error?
How can that be a genuine error? Why were you not allowing your head of institution to continue to communicate with Parliament? Because she had communicated with Parliament and gave a certain exact number. You can't get numbers wrong because the number of parliamentary seats is fixed. There's no fraction of seats in Parliament. It is either 276 or not. So you cannot gazette, you can't tell the clerk to Parliament in consonance with Regulation 43 2B of CI 127 2020 that I have gazetted 274, I have 2 outstanding, and then your director of election will use the back door and be communicating with the clerk and be giving different indications. And he goes to court in the name of the commission to now mislead the court that the Gazette notification that he had ordered to be done on the 6th of January was no longer a proper one, and that it is 24th. Meanwhile, there's an original letter before Parliament that the Gazette notifications were on the 23rd.
So you want the EC investigated?
The EC has to be investigated.
By?
Why? You are not interested in what is playing out here?
I mean, who will investigate the EC?
Parliament can do that, CID can do that, any investigating body can do that. And I'm going to raise this matter in Parliament. But because we are going for a review, I want us to settle the matter on review. And then we can look at the criminal conduct of some officers at the EC.
Criminal conduct?
Yes. You see, in pursuance of PNDC Law 284, especially Section 18, 1 and 2, your right to go to court will be deferred until the AC says I have gazetted.
Yeah.
That is why when parliamentary elections are held on a certain 7th of December, you cannot just, if you are aggrieved, you can't proceed to court. Even though there are some other case law that says that where you are aggrieved by the outcome of a public election, you can proceed to court with. No. Because it's very specific. And the authority in Boefio versus NTAC is very clear that where a law sets down a procedure for a right to be exercised, it's only that procedure that will be followed. So it is EC that will gazette before your right to go to court will be ripe. So if they toy with the dates, they dance with it. If they collude with somebody to confuse you with the dates, your right to go to court will be affected. And that's exactly what is at play in this matter.
So this is the basis for your review?
This is the basis for our review.
And post that, then you take up the issue in Parliament and it's a criminal investigation?
Yes, I believe that a full bench looking at this matter will return with a different verdict. You see, certiorari is a discretionary remedy. Because in Article 99 of the Constitution, the right to appeal the decision of the High Court in an election petition case is the Court of Appeal. That's the ceiling. So you can actually, that is why if you see Gary Nimaku's notice of appeal that he has filed in this matter, which is still before the court, they haven't withdrawn it. One of the grounds, in fact, the first ground of his notice of appeal is that the judge erred. There was a jurisdictional error. The judge committed a jurisdictional error.
The High Court judge.
The High Court judge. So that can be a ground of appeal. Now, how come they didn't end it there? How come they went to the Supreme Court for a certiorari? Because the certiorari is a discretionary remedy. And in asking a court to grant you a discretionary remedy, you need to come to court with clean hands. In my opinion, they didn't go before the Supreme Court with clean hands. And when the matter was asked, they claimed that it was a genuine mistake. The mistake we have discovered wasn't genuine.
But why didn't you raise this when the case was live before the court?
We raised it. So the judge found favor with us and dismissed so they had applied to dismiss this matter.
I mean, at the Supreme Court, this material evidence, was it before the Supreme Court?
You see, at the Supreme Court, with the certiorari application, the Electoral Commission had a duty to be truthful to the court. Because you see, I've been chasing them for this letter. They won't give me. This 23rd December letter, I don't have a copy. But they must produce it. They won't give me. So I had to go to them.
They told you they won't give you.
Oh, but if you go, they are giving you excuses. The commissioner is not around, the committee, and we had
the majority chief whip.
Oh, but they know. But it's about documents. So if you make reasonable efforts, that is why the rules are very clear that if you discover material evidence, even on appeal, the court will open that window for you to lead evidence. That is a material that reasonably were not available to you. If you discover it, which is material to the merits of the case, the court should be able to allow you. And that's the principle we are holding. So I had to go and dig this up in the Hansard. The Hansard is a verbatim recording or replica of what they brought. So as the director of elections, and you were a party to the case, you ought to be truthful that indeed the NDC went to court on the 23rd December because we are written to the clerk of parliament on that 23rd that we had gazetted the results, including Kpandai. That would have ended their case. The case would have died there, but they did not. He connived with somebody who was saying that the results, because Joy News reported that on the 24th December that the results had been gazetted. And so he affirmed that 24th December, and that is why, as we speak today, there is a gazette notification by Assembly Press for the 2024 parliamentary elections, 7th December parliamentary elections, bearing the date of 24th December. Officially. When the chairperson to that constitutional body says, no, the gazette notifications took place on or before 23rd December. So you think that somebody didn't deliberately deny the NDC this seat by his official act?
An act of omission.
Not an act of omission. It's a criminal conduct. You see, parliamentary seats are not merely political assets. They are also economic resources. MPs are paid. MPs take care of constituents. So it's such a valuable political tool to hold. And it goes to add to the power base of the political party in parliament. In any case, don't we count the seats for each caucus? We do. So when you take away one seat from me, as a majority chief whip, you are diminishing my authority and power in parliament.
What do you need that
seat
for?
You see, the day you discount a seat given to you.
Yeah, how many seats do you have?
Hold on,
8?
please. When I entered Parliament, MPP had 169 seats. Chain Mensa protected it like a valuable egg. He taught me that the day you tell a certain constituency that I have too many seats, so I don't need your seat, that is the day you kill your party in that constituency. And I don't want NDC to die in Kpandai. So I will advocate for this matter to be gone into its logical conclusion. Let the party know that we did our best in accordance with law. But we won't say that we are letting it go because we have 89 seats
Indeed,
in Parliament.
Protest in Kpandai.
Good.
From NDC supporters.
I traveled. I only got to know this morning that apparently Kpandai erupted. So we want to let the Kpandai people know that nobody is discounting the value of the seats that they gave us and was taken away. We will fight for it with everything we have. If we regain it, glory be to God. But we will make our case known. But we want them to know that we value the support base they give to the NDC. We won't do anything for them to know that we don't value what they have. Otherwise, the party will die on the ground.
And this Kpandai answer you gave, you were giving me a response about how fluid sometimes your work is.
Yes.
To explain, the issues that the General Secretary had raised about, the lack of consultation. What point were you going to make there?
Now, it's to say that we consulted. If you remember, that time, we were in court in Techiman South, Bekwai, Obuasi East, some other 2 seats in Ashanti region, Tema Central, Okainkwe Central, Okainkwe, Ablekuma North, Domiko Abenya, Suhum, those ones were filed in Kufodia, and then Akutia. And I was like the coordinator for all these matters. Eduji and his team, they were dealing with the Accra ones, but the outliers, we were to coordinate it and ensure that we got them. So these are not things that I did without consultation. But
the OSP bill you consulted?
No, OSP we did not. Okay.
That was his reference.
Yes, so I can accept. I accept it. I accept that we ought to have engaged. But if my boss says we should undertake a project, there's no way as his chief whip I will abandon him. You understand the point I'm making. So it was a decision we thought that in Parliament we could punish. Because what he did to Martin Kpebu was unacceptable. And he had, before Martin Kpebu, done that to Israel Aka, another lawyer, a good friend of mine. Israel went there with a client, and then you are locking the lawyers up. If lawyers come to see to the cases of their clients that are in trouble with you, as it were, and you are locking the lawyers up, what becomes the fate of the people they are there to defend? Martin must have made some comments. You invited him. Martin comes and he said for some comments, further comments he made, you were detaining him. Once you are detaining somebody, you are arresting the person. You are depriving him of his fundamental rights of movement. And I thought that all this amounted to abuse of office. So it was from that perspective, double with the fact that you were not delivering on your mandates in the way that some of us thought. So we put all this package together and thought that we could prescribe the office, but
the old man stepped in.
Yes,
the president stepped in.
Yes.
I'm going to take a quick break. When I return, he is the majority whip, let me argue, with the easiest of tasks in the Fourth Republic. He has a super majority. And, when you have that kind of majority, you don't have to whip too much because, everybody, you always will have a, quorum. You always will have your members to do business. I wonder how he's handling that. I mean, is it just cruise control for him? And how does he plan to maintain that number going into the 2028 election? I mentioned that because, as you know, the MPP had just elected a flag bearer, and he's a politician, so I'm sure they paid attention to that. His own party will go to that too. So there are a few things that as a majority whip you have to, of course, pay attention to. And how is he doing that? Stay with me. And you're still live here on PM Express. My guest is still Rockson-Nelson Dafeamekpor. He is the Majority Chief Whip. And PMS, this is always brought to you by Syntex Tanks, also brought to you by Pepsodent Cavity Fighter. And just before the break, I was indicating to him that he possibly is going to be the Majority Chief Whip with the easiest of jobs in the Fourth Republic. Nobody has 189 members under his whip. He has. And often the challenge when you're in government is, trying to get the government appointees and ministers all in the house to do business. He doesn't have that problem. He can lose almost 80 of them and they can still do business. Roxanne, I mean, this must be the dream job to be a whip with 189 members under your whip.
Well, it's a dream job to serve under the leadership of Mahama. Brilliant man. I respect him, but my regard for him has increased. When we were not in leadership, I always valued his judgments and legal arguments, debates highly, but having obtained the privilege to serve under him, he's a great guy. So, but the work is not easy because of the numbers. Where the numbers are bigger, the responsibilities are bigger.
Really?
Yes.
For a whip?
Yes. It's a principle in life. When the numbers are bigger, your responsibilities are also bigger.
In Parliament, it's
Are you saying the responsibility for Ano to whip a smaller number is bigger than mine? No. Because he has fewer numbers. So comparatively, he will whip his 88 members. That's twice or more of my responsibility. If he has 88, he has a full caucus to disturb me with. And he will get up and disturb me. And he does that all the time. Even if he has 70, that is nearly 80%. So he can worry me on the floor.
But you see, if you were the whip in 1371, which is what the last parliament had, that your tax would be immeasurably more difficult.
No, because I was close to that whip. I was close to Muntaka because we were part of the boys that helped him in the backbench to function and be effective. I was part of the same squad that helped Honorable Kwame Agboja when he succeeded Muntaka to be more effective as 137. But I'm saying that it's more difficult to get 189 members on the floor because my numbers are larger. And when the numbers are larger, the intervening factors are more. Especially also because I have some 33 ministers. Did you understand the point for me? So it's a fine balancing act that every time...
In your case, you can actually do with the 30. They can all go and work and you still do business.
Sorry?
You have 38 ministers.
Yes.
You can spare them. You can let them go and work.
No, but interestingly, government business doesn't function like that. A lot of, about 80% of the business that we do on the floor are government business. The government business is sponsored mainly by ministers and state departments. So you always need ministers. So to be honest with you, when we had leadership meeting today, we are thinking of how to be more effective with our ministers and how they can, assist to facilitate government business on the floor. So it's about managing the numbers because some of the reverse psychology that can affect us is that because we are many, everybody thinks, so even if I'm not there, the rest will be there. So we'll make up the numbers. Do you understand?
Yeah.
This can happen.
That is a complacency.
Yes. No, it's not complacency. It is a reverse psychology. You are thinking that, okay, we are many, so even if today I miss out, my other colleagues will be there. And that other colleague also thinks, oh, today, if I don't go, Evans will be there. Evans is saying, oh, today if I don't go, Rockson will be there.
Then nobody ends up coming.
Thank you. So you can be faced with such scenarios. So every time since becoming whip, my family will tell you, My sleeping times have been reduced because members, as the whip, you are the chief welfare officer. They have issues. They are calling you. Even if air conditioners, today you have to see our platform. Air conditioners are not working in some about 50-something offices, and it's all the whip, my air conditioner, because I can't stay.
But
in
the
my
parliamentary
office.
service, they should take care of the building.
No, that's parliamentary service. They are making the efforts to have it replaced. But the member is complaining to you. He says that, whip, for the past 6 months, we've been saying that you solve this. It's a capital expenditure matter. It's not been done. We are coming back, or we have reported. I still don't have air conditioner. You want me to stay in the office? How do I do it? He's complaining to you. He has some other complaints. And you are the whip. You are the one to complain to. And to be effective, you must respond to those complaints and attend to their concerns.
Proper headmaster task.
So you are, every time you are on edge, you're working to attend to the issues so that tomorrow when you say, I need you on the floor, they will come. But if you are not responsive to their needs, their concerns, their problems, they too don't respond to your whipping. So it's a quid pro quo sort of. If you are not effective as whip, forget it.
But you have a tool in your...
You lose your back.
You have a tool in your toolbox called a 3-line whip. When you
the 3-line whip, it's...
They can say no.
The 3-line whip is... It's something... It's a theoretical thing. It's an ideal thing. But the practical effect is what the people must feel. If you are effective, more effective, if you whip them, they come. They respond to your call. They'll come and perform the function or duty for which you summon them, and then they can go back. So you also don't deploy the 3-line whip frequently. You lose its effectiveness. So these days, I don't even mention it. If I need them.
Have you ever had an occasion to mention it?
Yeah. Especially before the budget and when the budget came. Okay. There were occasions. You recall days when I'm not on pro say, where are your members?
Exactly.
This report won't take it. After will say, where are your members? Sometimes it's politics. The members are we've sat for like long hours. And we've decided that those who there's lunch. So if you want to grab lunch, you can step out quickly and grab lunch. Once they see that members are going to grab lunch, then he has to play those mischievous politics. But my leader said this morning as part of the press briefing, he says there's never been any day that we need our numbers and we never had it. Anytime they raise the issue, they themselves don't like being told that they are not in the chamber. So when they hear opinion or are not saying so, they troop in to say, we are just around, why are you playing politics? So then they smile because they know that we can actually run shifts in Parliament with our numbers. Did they know?
24-hour Parliament.
Yes.
Yeah, now that you mentioned the majority leader, he said something today. Why do you want to change the name of the Kotoka International Airport to Accra International Airport? Oh,
I believe, to be honest with you, I didn't follow that discussion early, but I got in sync from about a week or two ago. Okay. When I read that some CSOs had gone to petition, I think the president or so, and they were staging some demonstration to have that done. So I began to follow the process. But for me, I would rather prefer that it's named after one of the gang kings than Accra. Because even though if they say Accra International Airport, a name like Kintakitewia or Gaumanche, or the one who died before, this one. When we were growing up, there was No, Gaumanche the second. He was the second, very famous. When we were growing up, he was the Gaumanche we all got to know. Or some famous Gan like Kwesi Saki, those people. So the symbolism will be more I feel the symbolism more and than Accra. You know, Accra is just like the capital. So, but the name change, I'm not for and against it.
A neutral.
Yes, but when we were younger, where Kotoka statue was at the airport, the historical account was that was where he fell when they killed him, when they shot him during the counter coup. So that was how come they erected the statue and named the airport after him. So the statue itself had been removed as part of the renovation works. I think sometime in 2002 or 3, when President Kufuor decided to renovate the airport, then they lifted. It was like a quadrangle. Yeah. The statue was in the middle on a pillar about 10 meters high, with a gun, if I remember. Yeah. Then the quadrangle was prepared around it. It's all been removed, and the airport has been remodeled. So it's only existing in name. If the plaque, if the statue is gone. So if today they want to take the nameplate and put another nameplate, even if it's named after Nkrumah, I even like that, because Nkrumah built it. It was built by the colonial administration, but he came to expand it. And so,
and then also still in Parliament, last year, we all remember the chaos that happened in the Appointments Committee. Yeah. You're one of those who was suspended.
Yes.
After the suspension was lifted, the Speaker told us that a committee has been set up to look into it. We haven't heard anything since. What's happening?
Truth be told, the committee's report has been ready. The chairman of the committee is Honorable Bedra. So I'm aware that the report has been ready. So this matter was mentioned, it wasn't on the floor, but it was part of the media briefings by my leader. One of the journalists, or a couple of journalists, asked him. And so once it's come up, I believe Speaker to pick this up in the media and may direct that the report to be...
The report has been ready, from what I understand, for a while.
Yeah, no, for a long time. It's been ready for over 6 months.
So what's the problem? It's like it smells of a cover-up.
No. It's been sitting on the order paper for so long. So I don't know the terms. I have never seen the report because, of course, being a subject. But I have always told people that my role was on camera. And I have appeared before the committee to speak to the issues. So I think that I'll be vindicated because I didn't misconduct myself. I was the one fighting that my business shouldn't be disrupted. I was preventing harm from coming to first my witnesses, my other appointees who have come, and the process. I was trying to save the process from being disturbed. So I'm not afraid about the terms or outcome or recommendations at all. So anytime the House is ready to take it.
You hear?
Yes.
Let me take you out of Parliament for a second before we wrap up. Yeah. MPP.
Yes.
What do you make of Bawumia's re-election?
I said, I think that I believe that he'll win. Yes, so that one was not in doubt. But then I said that he can't beat us. So I was actually rooting
How do you mean? You don't
I was actually rooting for Brad Champon.
Why?
Yeah, well, I don't know.
You think he's a more formidable candidate?
No,
or you think he'll be weaker against an NPP?
No, I think that, you see, young people, Brian is relatively younger. And I think that sometimes as a party, you give young people opportunity to develop and reorganize the party. You know how long President Mahama has, been groomed, sort of taken through. So he didn't come in as maybe somebody prepared. Minister, his back goes way back than that. But in terms of the being presidential apprenticeship, to be nominated, to receive the nomination as running mate from about 2007. You know, the discussion would have started around 2006.
Yeah.
So 2007, he got it, went into the campaign with Prof. Samuels, the whole of 2007, 2008, and then bam, we won. You see how long he's been around, you know, and he still look at his age. So it's important that we give young people, and I think Brian, if they give him the chance, he would do better than the others, but he didn't get a chance. So,
but Bawumia,
I wish them well, but Bawumia won't do better than he did in 2024.
What makes you so certain?
I think his baggage will be bigger.
How?
Or his burden. Okay, let me put it there. His burden will be heavier. Because in 2024, we were using GM's first term versus his performance with Nanado for 8 years. So a lot of young people who
had no recollection.
Yeah, have very little recollection. Not that they didn't have recollection, very little recollection. And the propaganda against GM2 was so deep. It cut so deep to the extent that GM had to say that Jehovah will vindicate me. You understand? Because it got to a stage we couldn't explain the issues anymore. We had to leave it in the hands of God. So he came onto the campaign trails with some positives to point to from he and Nanado's stay in power. Now, the stellar performance GM is dishing out is going to eclipse him.
That is, if it continues.
If it continues, it's going to eclipse him. So our candidate for 2028 is going to ride on that wave that GM will be leaving behind. And so the comparison will be between the NDC led by James Performance and Professor Jenana versus what Bawumia and his boss Nanado left for the people. That's how the comparison will be. And believe you me, it will be, the contrast will be so big.
But that also depends on who you elect to replace Mahama.
As we speak, the way we are working, it's immaterial who we pick. Yes, the way GM has structured its government and is delivering, it's immaterial who we elect.
The face on the ballot will mean something.
Yes, but it will be 30%. His legacy, the party in government and the president that we have now, his legacy will determine nearly everything.
On that point about who replaces him, MPP says you smell pepper. They have put theirs behind them. They are now trying to unite. They predict that he also be more acrimonious and bloody.
You see, we are not MPP. And we have done internal elections for many, many times. We are not acrimonious. Like the way they do. They when they have internal elections, they don't look at the eye of the other cockerel. they want to crash the eye of the other cockerel and win power. Look, Evans, I can tell you that MPP will have to do a reorganization. Even the NDC, we are reorganizing. They haven't reorganized. They just decided to do this.
Now they will begin to do that.
But how do you, like somebody wrote, how do you get your roof before you do the foundation? So they will have problems. And this reorganization, now they are talking about reconciliation. You haven't reorganized. And you are talking about reconciliation. So even to reconcile on the grounds will be like water and oil situation in many, many places. Because it's been so acrimonious. So acrimonious.
But yours is coming.
Ours is a friendly fight.
You see the guy's beard on fire, you have to fetch water.
Ours is a friendly fight. And you'll be shocked that everybody will give up for one person to go. We can do that.
Not when you're replacing somebody who has been there since 2007.
Yeah, I agree.
That's a long time.
I agree.
So that's where the challenge is for
I
me.
agree. But GM has been contested before. Have you forgotten?
He has been, yes.
Yes, it's been. It's not as if
He's always
it's
been.
not been.
He's always had an absolute.
But that's why I've been telling you that we will know how to do it. It's friendly fire. So we know how to manage our internal elections so that when we are done, the reconciliation is less difficult. But I have never seen that with the MPP. The last one, Alan today is not with the MPP because of internal election matters. So he left. So, anyway.
Well, that's Rockson-Nelson Dafeamekpor, and I need to repeat this. It says this bill,
consider it passed.
the legal education bill, consider it passed as soon as next week. Definitely before the president delivers it to the nation address. Thank you very much.
It's my pleasure.
Enjoy the rest of your evening.
My pleasure.